Well, hello everybody, and welcome to Law 2023 Online, Wills and Probate Shape the Debate with me, Professor Leslie King, and James Beresford. In this session, we'll be dealing with questions that you've already submitted, and we're due to last for an hour. And I guess before we actually start, we should do some introductions. So I will introduce James. James is a lecturer specialising in wills drafting and estate administration matters and helps his clients deal with their legacy planning, providing a comprehensive and understandable solution. He's a wealth preservation specialist focusing on inheritance tax for high-profile individuals and advising business owners on succession planning. I love this bit, James. You've been presented with two, not one, but two Private Client Team of the Year trophies at the Manchester Legal Awards, and is the author of No Will, No Say, A Simple Guide to Wills and Estate Planning, published in 2017. James's session for Law 2023 Online include the removal of personal representatives and common errors and negligence in will drafting.
Super, Leslie. Thank you for the introduction. I suppose I should add to that. I think the book is now the 1,400,000th most popular book on Amazon, with 2 5-star reviews from probably Mr. and Mrs. Beresford. So now it's my turn to introduce the lady who actually needs no introduction, Professor Leslie King. So Leslie is a leading professional author and a lecturer in wills, trusts and probate. She is a former member of the Law Society Wills and Equity Committee and the Probate and Estates Committee of STEP, and an honorary member of the Association of Contentious Trust and Probate Specialists. She is also a professional development consultant at the University of Law and writes and lectures extensively on private client matters. So as part of Law 2023 Online, Leslie's sessions will include achieving fairness in wills and exploring the residence nil rate ban and downsizing allowance. So to kick off, we're going to start by addressing the pre-submitted questions that we have been receiving from you. Leslie, would you like to start off?
I'm very happy to start off, particularly since the question that I'm starting with is one that has triggered all sorts of thoughts in my head, and actually I encountered a firm that had a very nasty problem in relation to exactly this topic. So the question is deceptively simple and short, and it's, what are my obligations in respect of a will that I am storing? And I suspect that quite a lot of people never really think about that at all. And of course, whenever you're thinking about what are my obligations in relation to something, you start with your retainer. What did I agree to do? And James, you can tell me if I'm wrong about this, but my suspicion is that very few retainers would say anything at all about storing the will and what obligations there are.
I think when I was in practice, the last terms of business that we would send out would say free storage of will and documents. Full stop.
Yes. For what purpose, to what end? What are you supposed to do with it? If your retainer doesn't cover something, then if the question came to court, what are you supposed to do with this? Or, you know, what were your obligations? And you haven't covered it in your retainer, then the court usually says, well, what would people expect to be in your retainer? You know, what would you expect to have covered? I had a quick look. I found very, very little guidance. I found a short piece from the SRA, Drafting and Preparation of Wills, which was updated in 2019. And they do have a section on storage of wills. What they say is that I think they're addressing people who charge a lot for storing a will, which, many solicitors don't charge anything at all, which you might actually want to think about. But what they say is you should alert your clients to low-cost storage solutions like the probate registry, which does apparently still offer that service. I heard it was going to be closed down, but apparently not. And then it says, your client may prefer you to store the will for them. And then this is the only relevant bit. The most important thing is to make sure your client understands the importance of their executor knowing where to locate the original copy of the will following their death. It says that they should make sure the executors know, they should keep a copy of the will at their home with the relevant details, they should keep you informed of any changes to their address or contact details, and review their will regularly to make sure it still reflects their wishes and circumstances, which is all terribly good advice, but not hugely helpful. The terrible problem that I mentioned, which one would wish to avoid being in this position, was a firm that was storing a will and had stored it for many years, and then discovered by chance that the former client had died many years earlier, and an earlier will predating the one that they were storing had been proved, and presumably the estate had been distributed. And so they were worrying about what are our obligations. And I suppose you go back to basic principles, which is you owe a duty of confidentiality to your client, which then passes to your personal representatives. You are required by the SRA principles to act with integrity and in the best interests of your client. So they presumably would have to contact the executor of the will that they are holding, who may or may not be the same as the executor of the will that was proved. In fact, I think in this particular case, it was a different executor. And you can imagine all sorts of awful problems flowing from that. And it just started me off thinking, well, should we be considering setting out what we do? Should you perhaps make a small charge for storing a will and in return contact the person every few years, as is done with pensions, basically to check that they're still alive and still at that address? And at least then you'd be alerted to the possibility that somebody might have died because they haven't responded to you. And you could then do perhaps a check at the probate registry. And you wouldn't be discovering 10 or 15 years later that there was this problem. So I think it's worth just sort of sitting down in your office and thinking what your firm's policy should be in relation to stored wills, and certainly bearing in mind the SRA guidance such as it is. Make sure that you have on record, in writing, something to the client saying, we're storing your will, but that won't do you any good if nobody knows that. So, please make sure that your executors and family members know where to find the will.
Yeah, it's an interesting one. I think it does come down to that wrong perception that wills are a cheap commodity, and we'll store it for free because it's the free thing to do, and we get that loyalty. A firm I did come across a few years ago, what they used to do was actually give the clients a credit card, basically saying your will is stored at ex-solicitors, contact us on this date.
Like an organ donor card.
Yeah, like an organ donor card. But I actually kept the one, so I hope my wife doesn't find that in my wallet one time. Else she may be barking up the wrong tree. But that was a good thing to have, because rather than here's your copy will in the will envelope that does say all the things that the SRA says, it's just another way of reminding the clients. And I would agree with you. I think the regular contacting of the clients, it will help making that client sticky, because it shows that you actually care about them. You want to regularly review the will. I'm a great advocate in trying to regularly contact clients, say every 5 years, with a, is everything okay? Do you want to review your will? And it keeps them with the firm.
Yeah. And also it stops the will, or you would hope, going hideously out of date, which is one of the things that I was talking about in my session on, fairness in wills. You get somebody who makes a will when perhaps they are quite wealthy, they go into care. By the time they die, their assets are, significantly reduced, and somebody who's getting a specific gift or a pecuniary gift gets a disproportionate share of the estate. Or, beneficiaries just get older, or, more are born.
Circumstances change.
Yeah.
Do you think, though, talking around the topic, though, do you think it would be worthwhile in the client care letters actually setting out, we will not contact you, tell someone because we have no liability in contacting you? Or do you think that would be going too far?
But you're suggesting that it would be a good thing to contact.
I think it is a good thing, but I think for firms who are looking at this, working out policies, it's I think it's either two routes of, we will not contact you. Tell your executors, or then the alternative is, for a fee, we will retain your will. We will contact you every 5 years.
You would have to be quite careful, because whenever we get a significant change in the law, which means that actually a will that you've drafted in the past may no longer be the best route, one of the questions that always comes up is, do we have an obligation to contact clients for whom we have prepared wills to tell them about this change? And I think it was the probate section got an opinion from Sian Warnock Smith, which said the retainer for preparing a will is normally a fixed closed-end contract. That's fine and good news. And I was then able to say to people, you may choose to contact clients because actually it's a good thing to do, but provided your retainer was, we draft this will and that's all we do, you're home and dry. So if you start to extend that retainer, you'd have to be very careful about, well, what exactly are we agreeing to do?
Yes.
I think once you've agreed to store the will, saying we will contact you every 5 years to make sure that you haven't died or moved, and that's all you're saying you're doing, that's fine. Once you get into, we'll contact you every couple of years to see whether or not you want to review your will in the light of changed circumstances, then you've got to do it.
Yeah, and then it comes to a resource issue as well for firms. You see some larger firms with a big private client department then having their own little mini department just doing the will reviews.
Yes. Yeah.
Going back through the will bank.
Yeah. So
it's interesting, and I can't imagine many people would have thought about it either. It's just always.
I hadn't thought about it until, as I said, I came across this firm that was grappling with what on earth do we do now, and it did make me think: do you want to store people's wills?
Yeah.
I mean, we always used to, because we'd always say, oh well, then you're going to get the probate, aren't you? But these days, increasingly, that's not the case. And, storing wills is an expense. And as we've just seen, could present you with some quite nasty problems down the line. Anyway.
I think it's going to start some debates in some private client departments across the country.
Right, shall we leave that one?
We'll move on. So one of the questions I've received, it relates to the point I made at the start about wills being seen as a commodity and cheap product. So the question was, how much information should be given to our clients if they want us to act as their executor? And there is a very simple answer to this, and there's the longer form answer to this. The simple answer is a lot of information, because in my view, the more information you give the clients, they are then able to make an informed choice on whether they want to have a professional executor or not. And I would tell them, the reasons why they may want to consider a professional executor in their circumstances, but then also cover the cost. And without relating it too much to it, when I was in practice, I think I would tell my clients 3 or 4 times during the process, as to why they should do this. And I think the Law Society and the Solicitors Regulation Authority practice notes on this are really helpful, because they do go into detail of, you must tell your clients this, you should tell your clients this. And, by putting that in both your attendance notes, I told Mr. X, I advised Mr. X he should have a professional executor in his circumstances for the following reasons, that would then protect you in the future should your appointment be challenged. And it would also give you the information at the time of death, if you are asked to renounce, the opportunity to review the will file, see exactly what was said at the time and the information given to the clients, and then you are able to give an appropriate answer to the clients. I'm a great believer in, one, giving the clients as much detail as possible to help them make an informed choice, but also keeping enough information on file to ensure that you have that information in time, because it may be 10 years, 15 years down the line when this comes to light, and the lawyer who prepared the will may or may not be there anymore to give that information. So a lot of information, I would say, whether that's through fact sheets, fact sheet of why have a professional executor or trustee, that could go out to the clients. Always include it in your covering letter, your will advice letter. Again, it just provides you with that protection on that. And having had over the years clients contact me and say, we want you to renounce, by having that information on file, and I always used to keep the correspondence with the will file, which I appreciate in the areas of, with storage costs nowadays, that may not be appropriate. But having that correspondence with the will, whenever you get that phone call, you've got the will there, you've got the correspondence there, you can look at it and you're able to calm yourself down before making any decisions.
Mind you, it's canned nightmare, isn't it? If the family want you to renounce, have made it clear they want you to renounce, they are going to be looking at every single thing you do and picking holes in it.
Yes.
So, as you say, you have to calm yourself down.
And I think as well, you've got to bear in mind as well, as do you want to act for a client or act for a family who does not want you to act for them? Because you may administer the estate perfectly, but they will still pick holes. They will still be dissatisfied. You will never be able to do right by them. But I think at that time, I remember one case I was involved in, and my client was the sole beneficiary and wanted the professional to retire. And the solicitor said, we are appointed because Mr. X wanted to appoint us, full stop. We will not renounce. And they did renounce in the end, but there's no information. And we did go back and ask for this. Please, can you tell us when you confirmed the costs? Ignored. Please, can you show us examples of the advice that you gave the client about the professional executor? Silence. So I think by having the information on file and giving it to the client, it's that first line of defence for you to be able to take stock and see, and then consider, as Leslie quite correctly said, whether you actually do want to act for the family or whether there will be any material harm of you stepping back.
The other thing, of course, is that if you've recorded the reasons that you were appointed, one very obvious reason might be, I'm a single parent, my children are young, I don't have a suitable relative that I would trust to do this, and because they're so young, they certainly couldn't do it. By the time the single parent dies, the children might be into their 30s and perfectly able to deal with an inheritance. So having the reasons is quite helpful because things change.
I don't agree. So it could be like a discretionary trust as well. If there's a discretionary trust and at that time it was appropriate for that trust to be put in the will, maybe through divorce or another family reason, and at the time of death, the trust, the family requests that the trust is collapsed because that issue is no longer there, it may not be appropriate, for you to, to act in that role. So I really do think, and as I said before, the Law Society, the SRA guidance is really, really helpful on it. You know,
It's very good.
and it's something that I find that people aren't really aware of, that there's such good resources available as part of the membership. And, you know, again, when I was doing this on the day-to-day, you'd start off there and build your policies around that, because you've got the guidance and it's structured in such a way. And also the Wix framework is a very good resource as well, which you can download and have a look at, and you consider whether you want to join that. But I now fear that I sound like a salesman.
Yeah. No. I'm just going to say I ought to just, because I was doing one recently and Wix was mentioned,
Yes.
and there were loads of questions saying, what is this? Because actually the Law Society doesn't really seem to publicise it very much unless I miss it. But it's the Wills and Inheritance Quality Scheme.
Yes.
Which I have to say I wrote quite a lot of, and it just sets out in relation to preparing wills and doing the administration of estates, the things that you ought to be doing at a fairly sort of high level of policy. But it does take you step by step through, you know, what you should be doing.
And it's a lot of helpful information, and you know, it's something, you know, I would say people should just have a look at, even if you don't want to sign up for the
you can just buy the booklet.
Yeah, and go through the booklet, and it's a very good statement of good practice. And I'm not saying that just because we're recording this together.
Okay, shall we move on?
Yes.
Now, we got in some questions which both James and I thought were kind of too fact specific to actually answer the question. You know, you just couldn't safely do it, but they raise some quite interesting questions. So I'm going to take one of these, and this is, can't find Auntie's will. Widower says it doesn't exist. Properties are in the UK and Barbados. Her estate was never settled. How can I get part of the estate for the kids, who are both adults, but not sure how to go about the inheritance they were promised? Now, I'm not going to try and answer that question, but what leapt off the page to me was that we were promised. And people so often go, but, you know, Auntie always said that I would get everything. And you have to go back to the basic principle, which is we have testamentary freedom in this country, subject only to the 1975 Inheritance Act, if reasonable provision hasn't been made for your maintenance, and also to proprietary estoppel. So, and also, but unlikely, so I'm not going to say any more about this third possibility, but you could enter into a contract with somebody that if they gave you X, you would leave them Y in the will. So it is legal and legitimate to enter into a contract, but it's very rare. What's much more common is either the 1975 Act route or the proprietary estoppel route. But proprietary estoppel is much, much more limited than many people think. In order for a proprietary estoppel claim to arise, one person has to have promised to leave something in their will. And this is the crucial bit. The promisee has to have relied on that promise to their detriment. And I vividly remember having a long conversation with somebody in the break at a conference where he was saying that he got the survivor of a cohabiting couple, and the man who had died had promised that he would see she was all right. And he was going, this poor woman is devastated. You know, what can I do? Has she got a proprietary estoppel claim? And I said, well, did she rely on this promise to her detriment? And he said, detriment? Well, of course she's worse off. She's worse off because she isn't inheriting anything. And it took an incredibly long time to get to, no, it's not the fact that she hasn't got what she was promised. It's, did she rely on that promise and do something to her detriment? So, you know, typical thing. I need somebody to care for me. I get some member of my family to give up work, you know, live in my house in return for of food and accommodation, but they're no longer earning anything, but I promise them that I will leave them the house when I die. Now, conceivably there you have got detriment, because although they're being housed and fed, they've given up a job. Happens a lot with farming cases where, one child is promised the farm and then there's a falling out within the family, and they go for a proprietary estoppel claim saying, I've worked for low wages all my life relying on this promise. And other siblings or the parents, if they're still alive, often say, actually, that's not true. You've been housed, you got free accommodation, you got your car through the business. We didn't pay you a lot, but you wouldn't have earned much more if you'd gone and worked somewhere else. So proprietary estoppel, the key is detriment. And certainly there's nothing in this question to suggest that the children have suffered any detriment, or even, so a proprietary estoppel claim looks like a non-starter. 1975 Act claim by children, certainly if they're adult children, is quite a difficult one to make stick, because you have to show that reasonable provision wasn't made for your maintenance. And if you are an adult and you are capable of meeting your own maintenance requirements, then there is no reason for somebody, your parent, to leave you anything. Reasonable provision may well be nothing. So I suppose all I'm saying is, when people come along with a hard luck story saying, we haven't got what we were promised, although it's very unpalatable, actually, there may be very little that can be done. Now, it's quite different if there are queries about the validity of a will, for example, or if there's a suspicion that there is a will but it's being concealed, although that's pretty difficult to deal with in practice. But do you have anything to add, James?
Or unless it's in a solicitor's will bank and forgotten about. No, going back onto the first question. No, not really. I think you're right. I think, especially with Islet and Mitson, in my own view, was quite badly reported at the time. I still think it is very hard to bring a successful claim, especially as an adult child, under
I think
1975.
Islet and Mitson absolutely underlined how difficult it was, and absolutely emphasised the principle of testamentary freedom. And I have noticed in 1975 Act claims since that, judges, that tends to be where they're starting from. So they say, it is for the applicant to convince us that reasonable provision for their maintenance wasn't made, and also to convince us that it is appropriate to take away from the chosen beneficiaries of the deceased.
But no, there's nothing really, like I said, there's the two areas to consider on that one. So I'll move on to one of the other questions I've had. Should I just follow on from the first one about the first question that received was about how much information we give to the clients, and then this next pre-submitted question was, do you think we can have a blanket policy of not renouncing executorships? And in my view, the answer is no, you cannot have a policy. The case I mentioned before, that was their thing. Our firm's policy is not to renounce executorships. We were appointed the executor and we will not be renouncing. I would say that's an unwise policy to have, because you need to look at every case on its own merits. And without going into too much detail, because we discussed it in the answer to the first question that was posed to me, the reason for your executorship and being named as the executor in the will may no longer exist. And using Leslie's fine example, you've single parents with young children, and you're appointed because there's no one else suitable. When the time of death comes, they may be in the 30s, they are perfectly able to deal with the estate. There will be no need in you acting. And then it comes down to the dissatisfied clients, and it can flow from that with the increased need of complaints. the feedback. There's the statistics about, and I'm not going to embarrass myself by trying to quote them. I think they're on the slides, but happy clientele's 3 people, a dissatisfied clientele's however many. There was a famous one, I think it was a dissatisfied customer of American Airlines ended up telling like 6 million people because he recorded a song about it. And it went viral on YouTube. So I think these are all things that you have to bear in mind. So my thoughts would be to treat everything on a case-by-case basis. And if the requirement for you to still act in your professional role is there, you should be able to jolly well say to them, there is a reason we are here to act. We were appointed, and these are the reasons. You should be confident in that, provided you have given that the correct advice at the start, and you've given the client the option when they were making the will, and explained to them, yes, you can have the layperson, but again, I think it's reassess everything at the date of death, look back over the file, see what the reasons were for the appointments, and then consider each case on its own. And I think I would say that a blanket policy would be unwise. Leslie, any thoughts?
No, I have nothing to add to that. You seem to have covered it absolutely perfectly.
Super.
So, shall I look at one of mine? I think I'm going to look at one of my residence nil rate band questions. So let's take this one, which I find is quite a common sort of general area of doubt. So this question is, if a residence is in one spouse's sole name, if the first to die is not the owner, then is there no residence nil rate band to transfer? So take a simple example, me and my husband, house is in his sole name, I die first. I have no residence. So is my residence nil rate band going to be passed on to my husband? Answer, yes. It doesn't matter that I didn't have a residence. The question that you ask when dealing with transferred residence nil rate band is, did the person who died first use their residence nil rate band? To the extent that it was unused, and the reason is completely irrelevant with one exception, which I will come to in a moment, but it doesn't matter that you didn't have a residence, doesn't matter that you had no assets, so IHT wasn't even an issue. Doesn't matter when you died. None of that matters. Question, did your estate benefit from the residence nil rate band? Answer, no. It is passed on to your surviving spouse or civil partner, unless the estate of the first to die exceeded the taper threshold. And if you exceed the taper threshold, your residence nil rate band is reduced. And if, for example, I died with £3 million in my death estate, then I have exceeded the taper threshold by so much that I have nothing left to transfer. But that's the only situation where you would worry about not passing on the residence nil rate band. However, I'm going to add one thing to that, because this is another really, really common misapprehension. Once it's passed on, the survivor doesn't have 2 separate residence nil rate bands. What they have is an enhanced residence nil rate band. So if I've passed the whole lot to my husband, he has a double residence nil rate band, a residence nil rate band which is twice as big as anybody else's. That's really important, because having an enhanced residence nil rate band doesn't necessarily mean that you can use it. You've got to have a residence when you die, which you leave to lineal descendants. And so often I get people going, oh, well, when the survivor died, they didn't have a residence, but the first to die did. And so can't they use that residence nil rate band? No, it doesn't work like that. You have an enhanced residence nil rate band. If the survivor's estate is going to benefit, they've got to fulfill the conditions. Now, it may be that they're entitled to a downsizing allowance because they disposed of a residence on or after 8th of July 2015, which is a slightly different thing. But, you've got to qualify for the downsizing allowance. So if they die and they leave everything to, I don't know, nephews, cutting out their children and grandchildren, then no residence nil rate band's going to be available. So that's me done on that one.
And who says tax doesn't have to be taxing? If you remember the advert, so maybe that's just a very niche joke there. I've got one last question that's come through about the removal of personal representatives, which I'll just want to cover off. And that would be, do you have any practical suggestions on what we can keep on file if we are appointed as executors? And some of this has probably been covered in the answer to the first question, with the broad stroke of as much as possible. Keep everything on file. Even your handwritten attendance notes. I'm a great believer in your attendance notes is your shield, and I would always have my handwritten attendance notes with very poorly drawn pictures for clients, with poorly drawn family trees that are then typed up. So we've got everything on there. So we've got the handwritten, we've got the typed up. So when it comes to this particular aspect, you'd want to keep the handwritten attendance note. You'd want to keep the detailed typed up attendance notes. And bearing in mind that one of the chaps who trained me, his version of an attendance note was basically written on the back of a napkin. As my career progressed and saw some of the other attendance note I came into contact with, my view certainly changed. Although there is a limit to the detail on it, but I think the more detailed, the better. In that, this way you're covering when you're talking about these executorships, about that they can have a layperson, friend, family member, a professional, go into the detail of what the advice you give, what would be appropriate in these circumstances. So you'd keep that on file. I would then suggest in the initial letter that you send to your client, whether that's one letter providing advice prior to a draft, or if you're being efficient, it's the letter of advice and the draft combined. I would include that on the file. So you have chosen to appoint X and Y as your executors. The reasons are as follows. I would include your current costs in there at that time. As I mentioned before, I'm a great believer in fact sheets. I would keep a copy of that fact sheet on the file on your correspondence clip as well. So you've got evidence of the version of that fact sheet that you sent to the client at that particular time, because it may go through very many iterations by the time of death. So you know exactly what has been done there. And if you send out a will summary, and I appreciate maybe going over the top of this, but a will summary, include it in there. And finally, when the will's signed, you're sending out the copy. It comes back to the storage point from the first question. You may wish to put a paragraph in there. You have appointed us as your executors. You need to ensure that we are informed when you die, or something along those lines. So the more information, the better. I think the more information you give your clients at the time, the harder it would be, subject to the point about acting for dissatisfied clients, the harder it would be for people to try and ask you to renounce at a later stage. Leslie, any comments, anything you think there?
All I'd say is that everything that you said is absolutely right, and it doesn't just apply to keeping information in relation to renouncing an executorship. That's all the stuff which is absolutely crucial if somebody later wants to challenge the will.
Yes.
And also I've been lecturing a lot about avoiding misunderstandings with clients and spending time when you're taking instructions, drawing a family tree. I'm a huge fan of drawing a family tree with the clients and to make sure that you've got it right. And this problem about the in-law relationships, you know, when they talk about my nieces, what do they mean?
Yes.
Do they only mean their blood nieces, or do they also mean the nieces of their spouse?
Yes.
And that's often a problem.
I think as well, it comes to this complete misconception that wills should be cheap.
Oh, yes.
You know, and you hear it so often, especially when clients say, "Oh, I'm not paying that for a will. You know, I can get it for £9 online." You think, you can. And it really does bring, I think it's Benjamin Franklin, was one of my favourite quotes, was, "The bitterness of poor quality will far outlast the sweet sensation of low price." I know, you know, before the pandemic, that was always my opening slide when we're talking about will drafting, because it's so true. Yet we have firms that still say, "Oh, we can only charge £150 for a will."
And the problem is, okay, you do lots of cheap wills, but if only a tiny proportion of them are challenged, or you know, you get dissatisfied clients or beneficiaries for whatever reason, the amount of time that is going to be taken up with dealing with that. I mean, anybody who's been involved in litigation, I was talking to somebody only recently who said they still woke up at night with kind of, you know, cold sweats about how awful the experience had been. So it simply isn't worth it.
And as well, I agree with you on that, because in my past, we used to help a lot of firms who had the claims made against them. And you go through the attendance notes, and there's one, and I really felt for the lawyer who prepared it, because it was a mutual will claim. And all the way through reading the attendance, she just didn't say the wills mirror each other in their terms and are not intended to be mutual. You could see she was alluding to it, and it was what she meant, but it wasn't written down. And you read it, it's like, oh, come on. You know, it's like, please, on the next attendance note, please say you'll say this. And they didn't, which...
So this was a claim that the wills were mutual.
The wills were mutual.
They were merely mirror.
Yes. Yeah. And it was...
Because one of the things that I always say to people is, if you're doing wills, particularly for, you know, second marriages where there's going to be children on either side, if the wills aren't intended to be mutual, it's a very good thing to say so in the will.
Yeah.
You know?
So the will was silent. The wills were silent on the point, and then the attendance note, you could see, you know, it's just that he just wanted the extra sentence added to the attendance note.
You will be free to change your will as you see fit.
Yeah, the survivor of you can change the will. They merely mirror each other in their terms. And you know, I think no one, in my experience, and I appreciate I'm just moving on from the question, I don't think people are actually trained as junior lawyers on actually how to write a proper attendance note. It's a skill that I think we do need as lawyers to develop, and it's not particularly taught well. And I think in practice, it's something people should be doing with the trainees and newly qualified. So this is the standard of attendance note we expect.
That's just kind of triggered something in my mind. There's a case that I've been lecturing recently where a relatively young paralegal was given the job of drafting a new will for somebody, and they had already been into the office and given instructions face to face to another fee earner. This other fee earner said it's above my pay grade, so passed it on to this actually not terribly experienced paralegal, who, because it was a few weeks after the initial instructions had been taken, telephoned the client to confirm the instructions, wrote down the instructions, which differed from quite significantly from the ones that had been given initially. And she then prepared the will on the basis of the instructions that she had received, did a covering letter, which was unfortunately ambiguous,
Oh.
but nowhere did she explore the reason for the difference between the instructions. If she'd done that, she'd almost certainly have found that there was a misunderstanding. And I think point number one, always record the reason for a change, either from the previous will or from the previous instructions. If that's what happens, record that. And then always in your covering letter, try and explain the will as clearly as possible. And lots of cases where there's been, discussion about did the testator understand this will or not, cases of lack of knowledge and approval. What the judges often say is the will was written in the typical difficult, abstruse way that lawyers write. The one I love is the one who said that the typical substitutional gift was gobbledygook to most clients. And I always think it's worth saying, property is left to your children. If one of your children, for example, Fred, dies before you, actually bringing it down to the particular and naming people helps a lot. It kind of focuses people's minds. And what the judges say is there is no point in simply repeating the wording that is in the will in your explanatory letter, because it gets you no further.
Yeah, I learned at an early stage, and I used in a letter I wrote to your issue. And I remember the client phoned and said, "What are you saying? I don't have any issues." I was like, okay. I think I must have been 1 year qualified, and it really brought it home that it's language that you use on a day-to-day basis in the office, but to 90% of the population, it's gobbledygook.
I've forgotten. Was that my question or your
question? No, that was my question.
Okay, I'll do one then. So this is a non-residence nil rate band question. This is, if an attorney sells a house because P has gone into care, will the Court of Protection make a statutory will where the house was left to a specific beneficiary? Which is quite a wide-ranging question. I mean, the answer is quite possibly, but first of all, you'll have to make an application, and the application is expensive and requires an awful lot of information. And this is assuming, of course, that, P has lost capacity and can't make a will. And one thing that's just worth saying is somebody may have lost the capacity to manage their property and affairs, which is why they might have an attorney acting for them. But of course, they might be able to make a simple will. And, if you said to somebody, you left your house to Fred and everything else to Ethel, now the house has gone, what you've got is money, Fred's getting nothing, Ethel's getting everything. Is that what you want? It's quite possible that they would say no and actually have the testamentary capacity, although you'd obviously want a medical report, to make their own will. And that would be a lot cheaper and easier than applying to the Court of Protection for a statutory will. If you go to the Court of Protection for a statutory will, they will want information about what the original will said, what the assets are, who the possible beneficiaries are. But this is a prime example of a situation where something has happened, which means, certainly on the face of it, that P's testamentary wishes are not going to be put into effect and somebody is going to lose out. So it is a situation where you would expect the Court of Protection to adjust in some way. What they wouldn't necessarily do was they wouldn't necessarily say, oh, well, in fact, they almost certainly wouldn't say, well, the house was sold for 400,000. So we'll redo the will to give 400,000 to Fred and residue to Ethel, because of course that the proceeds of sale may become a very disproportionate part of the estate. So they're much more likely to look at what proportion was Fred getting when he was getting the house. How does that relate to what there is at the moment? And even more importantly, what's the life expectancy of P? If they're paying their own care home fees, how much are they likely to have when they die? Well, how long's a piece of string? You can't know that. So probably what they would do is they would give parts of the residue. They would simply divide the estate up into shares, so everybody would get something.
I suppose the other thing to think about with the application to the courts of protection is the current time frame as well.
Oh.
Yes.
Don't do it if P is in poor health and has a very short life expectancy.
Oh, okay. Well,
yeah, go on. No,
I was going to say, with time moving on, I was going to pick up one of the questions that we had on the negligence and will drafting, and then Leslie will let you have the last question, if that's okay.
Okay.
So, yeah, one of the questions I've had on the negligence and will drafting webinar was, you mentioned a preference for a client questionnaire rather than a will questionnaire. Why? Well, I do have very strong views on this because I've seen both types used by firms. So it may help if I just give a quick explanation of what I mean by that. So a will questionnaire is questionnaires I've seen used by firms where the client would fill in the details and it said, what would you want to happen on your first death? Do you want everything to spouse? Everything into a life interest trust for spouse? Everything into a discretionary trust? For example, what would you like to happen on the second death? And then the client fills that in and sends it into the office before the meeting. So that's what I mean by will questionnaire. A client questionnaire is different. This, for me, is an information gathering exercise where it's who you are, where do you come from, tell me about your assets, tell me about your business interests, tell me about your family. Let's build a picture up of what we're dealing with. And you get your clients to fill that in before the meeting. I always prefer a client questionnaire over the will questionnaire because, for various reasons. One, if you get your clients to fill the client questionnaire in beforehand, it shows they are invested in the process. They want to do this because they are doing their homework prior to the meeting, for want of a better expression. It also enables you to get a picture of the client and their circumstances before the meeting. This means that the appropriate lawyer can see them to take instructions. I had it once in practice where it was the daughter of a very wealthy family that the firm out for, but she got married and no one put the two and two together. So as a newly qualified solicitor, I got sent in and she was worth 20 million. I was really out of my depth and it was quite embarrassing for all concerned. If we'd done a client questionnaire before that, and we'd seen the net wealth, it would have been the head of department seeker, not me. And also with a will questionnaire, to me, they fall down because people don't know what they don't know. You are asking someone with no knowledge about succession law to decide what they want to go in the wills. And that's dangerous. I've seen it with online will preparation as well. One of my old firms used to do a lot of these. And you'd see these wills being printed where you've got life interest trusts, discretionary trusts, because people go, oh, I'll have one of those. Does it cost me any more? No. Oh, I'll have one of those as well. So without providing advice, I don't think a client knows what they want. They'll only know what they want after they've taken the expert advice from you. So I am a great advocate of the client questionnaire to get that information first, because you can get the appropriate person seeing the clients rather than say to a client, you pick what you want. Because one, it demeans the advice that you're giving, and also they have no idea what they want because they won't have thought about, for example, if it's a couple, the survivor of them potentially remarrying. That won't even cross their mind. It's for us to provide that advice and provide the structuring. But I do feel that's my rant for the hour over and done with on that.
I'm just going to add very quickly that I was out to dinner and I happened to be talking about, awful wills cases and, how terribly things can turn out. And the two people that I was having dinner with, who were both quite high-level city lawyers, said, oh, well, there's no problem for us because we're just leaving everything to each other and then to the children. And I just said, and if one of you dies today, would you expect the other one to probably get a partner at some time in the future and a whole new life? And they were, oh, we really hadn't thought about that. I found it quite extraordinary, but we're so used to dealing with these family situations that we just forget that other people aren't.
Yeah, and I think I always find once you engage people in the process, I always say to my clients, I've said to my wife that I wanted to live like Miss Havisham for 5 years after my death, find the wedding dress, and then after 5 years she can meet someone else. But we've structured our will using a life interest trust to ultimately benefit the children. So I think once clients understand the risk and what can happen, then they will follow your advice. And that's where we as lawyers add the value.
That's what they're paying us for.
Exactly.
They're not paying us to just write down what they say they want.
But again, when a will seems a cheap commodity, I think the risk is that you do the will the client thinks they want than the will that the client needs. And that's the risk I think people will take if they continue to treat wills as low commodity. So that does bring us to the last question. So Leslie, over to you.
Which one to take? Okay, I'm going to take one of these ones where I can't answer it, but I'm just going to say a couple of things that it raises. So because it's probably quite a common situation, this testator died in a care home. She left a will appointing one nephew out of 9 nieces and nephews as the sole executor and sole beneficiary of her estate. Never married, had no children. A niece was her sole attorney under an LPA. The niece sold the testator's property to pay care home fees, but used a large chunk of the sale proceeds to purchase another property through a company that she owned. And the question is, how is this situation dealt with when considering what forms part of her estate on death? And attorneys kind of misappropriating funds is something that does happen, from time to time. And I suppose the first thing to say is that it's no good going to the Court of Protection because they're not interested once P has died. So their concerns is what is in P's best interests while P is alive. If you really think that an attorney has helped themselves to, chunks of the estate, there is quite a useful criminal provision to be aware of, which is, I think it's section 4 of the 2006 Fraud Act, which is fraud by abuse of position. So you could actually get the police involved, which isn't going to help you get the assets back, of course, but you would be looking at just general legal principles. So if someone who is in a fiduciary position has taken your assets and bought something else, you actually have a remedy in equitable tracing. So you would lay claim to the asset that had been bought with the proceeds of sale of the original asset. So equitable tracing is one of those ghastly things which we all did at law school. It involves was it the rule in Clayton's case and first in, first out, but in principle it's just follow the assets if you can. I'm going to stop there.
Well, and so unfortunately that is all we have time for today. I'd like to thank you for attending LAW2023 Online, Wills and Probate Shape the Debate. Please don't forget the solicitors group LAW2023 Online community on LinkedIn to continue the debate after this session and to be included in offers for future events. If you have purchased the online course, there's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And for those of you who haven't, there's still time to buy the complete event, including a recording of this session. To book, all you need to do is to go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire package, you can claim your free 1-hour CPD webinar from the webinar learning catalogue and that's worth £35 plus VAT. Finally, after viewing the online course, please complete the feedback form that's available in the related links section, and you'll receive your CPD certificate via email. So all that's left for us to say is thank you again, and have a great day.
Beautiful, James. You could be a presenter. Yeah, thank you for watching, and I hope that you found it useful and interesting.